in Brazil, we've recently seen with the advent of Santo Daime, I'm kind of taking a bit out of context because Bia was talking about things I want to remember to talk about. But what's auspicious about being here is that, essentially the reason why the civil governments are prohibitionist against entheogens really derives from the churches back in the 15, 16, 1700s. The idea being that these drugs were essentially little devils, and they would make people stray from the dogma. And that dogma being the dogma of Christ. And then because the religious authorities often determined what would become criminal laws, we have all of these laws today. But it's very interesting because in Brazil, and I'll talk more about this, Santo Daime is a Christian religion. And that Christ brought this tea, made this tea available as a vehicle to become closer to the divine. In Brazil, the Catholic bishops of Brazil honor the Santo Daime as a valid Christian religion. So here, Christianity was the reason for the prohibitionist attitude. Now we see in Brazil the Catholic bishops are saying that this is a legitimate Christian church. And here we are today in a Christian church talking about it. And I think that's pretty amazing. Now, yesterday, I can't remember whether it was in your talk or someone else's, where the subject of using psilocybin or MDMA to treat dying cancer patients to alleviate the fear and some of the suffering, that was a topic of discussion. Someone then asked the question, well, why does it have to be limited just to people who are dying? You may recall that question. But then there was another question from this side of the room was, well, why can't we take it because it's fun or because we enjoy it? And that was a very presumptuous thing to suggest. You all, I feel in my back like my sarcasm is starting to arise. I may not be able to control myself. You voted to put these people in office. You put them there because they knew more than you. And they've decided that you should not be able to engage in feeling better. But you can do it maybe if you're dying. Now, these legislators also decided that there's a group of drugs. And the Controlled Substances Act lists a whole lot of different, we'll call them chemicals. I have so much trouble with the word drug. And they're all scheduled the same. Now, these are the people you elected. When Congress passed the Controlled Substances Act, Dr. Hollister, who was the chief psychiatrist of the VA, who was one of the more experienced psychiatrists in the country about drugs, he said the following. I want you to listen to this carefully. This is about classifying marijuana, LSD, DMT, all in the same classification, because you voted for these people to do it, so you wouldn't get into trouble. Hollister said, I can find no colleagues who will state that the scheduling of these drugs makes any sense, nor am I able to find anyone who was consulted about the proposed scheduling. This is your Congress, and this is what an expert is saying. This scheduling, which groups together such drugs as diverse as heroin, marijuana, and LSD, perpetuates a fallacy long apparent to our youth. These drugs are not equivalent in pharmacological effect or danger to individuals or society. Meaning the entire process was irrational, and there's no basis for it, and yet it's all grouped as one thing. I want to start off by talking about the Native American church. Most of you are probably aware that the Native American Church is composed of Native American people who take peyote as the central practice of their religion. Now, peyote's been around for a long time, and when the tribes were conquered, the goal was to turn these savages into good Christians. And so Native people had their hair cut. Their children were put into BIA schools where they were beaten. And the whole attempt was to really create genocide for cultures that had been in this country for years. Part of that was forbidding the use of peyote. As the Indian tribes began to have some power in Congress over the last 50, 60 years, and had congressmen and senators on their side, the Drug Enforcement Agency, the DEA, granted an exemption for the non-drug use of peyote by Native Americans. That's the only time anything like that happened, and it's only because Native Americans had political power and pressure to do that. That's something that neither the Santo Daime nor the UDV don't have that kind of political power in this country to have gotten the government to do the right thing, which would be to have granted that same exemption, because this is all a non-drug use, based upon the definition of drugs as used by the Justice Department. Now, even though Native Americans were given the right, if you will, to take the peyote, in 1990, there was a case that came out of Oregon, which is where I'm from, and I had some involvement in it. There was a drug counselor working for the state who was also a member of the Native American Church. And he told his boss that he was participating in peyote ceremonies, and he was fired because drug counselors can't take drugs. That case went to the Supreme Court. Now, prior to that case getting to the Supreme Court, we had a very useful, appropriate body of law regarding when the government can interfere with religious practices. And what it said essentially was, if the government has a law that's neutral on its face, but that law burdens the practice of someone's religion, not only does the government have to show that, well, it was neutral, it wasn't passed to hurt these people, they have to show that there's a compelling interest in applying that law in the particular circumstance. And so that was a heavy burden on the government. When this case went to the Supreme Court eviscerated what's called the compelling interest test and said, well, the law wasn't passed specifically to go after Native Americans, but it's a crime. And if somebody's committing a crime, then they can get fired. It was a terrible decision. Parenthetically, I was involved in it. I represented the Native American Church, and I had put together all the Catholic bishops in the Northwest who met with the Attorney General of Oregon and said, this isn't good. God doesn't want you to do this. And nevertheless, it was done. The named plaintiff wanted to go through with it, even though the Native American Church and all of us were against it, because we had an inkling we were going to get a bad decision, and we got a bad decision. The result of that is Congress, 2 years later, passed the Religious Freedom Restoration Act. And the purpose of that act was to override the bad Supreme Court decision and bring back the compelling interest test, meaning that the government has to show that something really bad, that they can prove that something really bad is going to happen if they don't apply this law to a particular situation. Now, I wanted to touch for a minute on where do we find our protection here? The Ninth Amendment to the Constitution states that, quote, the enumeration in the constitution of certain rights shall not be considered to deny or disparage other rights retained by the people. Now, one of the rights retained by the people is to be able to do what you want with your body. That Ninth Amendment was used by the Supreme Court in the abortion cases, saying a woman had a right. However, it's been rejected, irrationally rejected, as a basis for protection for people using entheogens. And so that doesn't work, but the First Amendment, the religious freedom embodied in the First Amendment, that's where we have concentrated our work. Now, regarding the Santo Daime, let me briefly take you through. The ayahuasca has been used for thousands of years. The myth is that it was the plant gods that taught tribal people how to use it. They weren't sitting in their labs with Bunsen burners, but the plant gods taught them how to do it. In the 1800s, when the Portuguese came into Brazil, they attempted to do the same thing we did to the tribes, but they really were not as bad as we were. They tried to bring Catholicism to the tribes, but they didn't do the horrendous things that we did. In the early 1900s, there was a young rubber tapper whose name was Raimundo Irineo. He was a tall black man, African descendant. He was raised as a Catholic. But he was doing ceremonies with the tribes. And in one such ceremony, he had a vision of the Queen of the Forest. And the Queen of the Forest said, "Go into the forest and do the tea for 7 straight days, and I will instruct you on a new religious practice." And that is what Master Irineo did. And he recognized that it was Mary who took the form of the Queen of the Forest and taught him what the new religion would be about, called the Santo Daime. And so this is a religion that evolved in the Amazon, and it contained thousands of years of practices and current beliefs that Jesus is the Savior. Now, in Brazil, the religion spread, and the government, Bia mentioned this, the government undertook a study of the religion, and they appointed a committee. The committee went to some of the religious communities, some of the members did the tea, and eventually the committee basically stated that these communities where Santo Daime is being used as a religious practice, the people there have gotten past drug use, alcohol use. They live very, very respectable lives, is essentially, and so the government permitted its use. In 1999, a church had been established in Ashland, Oregon. And at the same time, there was a church that the União de Vegetal had in New Mexico. One day apart, and to this day we don't know how this happened, both churches were busted. One of them was in Oregon. The tea was coming in from an entirely different place. Another, New Mexico, tea coming from an entirely different place. And to this day, we never found out, even though we were able to subpoena a lot of the records. Now, this was in 1999. I had looked this over, and I'm in Oregon, and Oregon had granted an early exemption to peyote. And I had decided that the best place to begin this process was to see what could be done in Oregon. And I'll run through this quickly. Each state has a board. Some states call it the pharmacy board, and they have concurrent jurisdiction with the DEA over drugs. I hired the former president of the Oregon Pharmacy Board as an expert witness and had him evaluate the case. Now, that case that I put together for him involved John Halpern, who has done the peyote study and did a study for the Santo Daime, which established that there's no data whatsoever that any short or long-term ill health effects have occurred from the use of peyote or from the use of the daime. I had several anthropologists, religious freedom experts, and we put together our case in writing. And the former president of the pharmacy board presented it. And sure enough, the Oregon Pharmacy Board issued a ruling that said that the Oregon Pharmacy Board did not have jurisdiction over the tea because it was a non-drug religious use. And that was unbelievable. It's the first time that ever happened in the country. I took that, and this is in 1999 when Clinton was still president and Janet Reno was the Attorney General. Two of my drug policy experts were friends with Janet Reno. They wrote to her and they said, this is a legitimate religion and you need to get the DEA to back off. Reno put together a committee of 10 drug agencies. This is in November 99. And I met with them and they began to see the light, and then we lost the election. George Bush came in and Ashcroft became Attorney General, and it all ended. Any attempt to settle it ended. Now, in my discussions, my letters with the Department of Justice, I was saying, okay, why not? What are the compelling reasons? Because the Religious Freedom Restoration Act said that before the government can enforce a general law that burdens a religious practice, before they enforce it, they have to determine that there's a compelling interest to enforce it. So I'm sending in a letter and saying, okay, we understand. What's your reason? The letter that came back was, we haven't figured out quite what the reason is. You've got to understand how serious that is for them. Another letter went out, and the same response. Finally, in August of 99, I got a letter from the Assistant Attorney General saying that they were not going to permit the tea because it would violate treaties, that the tea would make people sick, short and long-term ill health effects, and it would be diverted. Now, I want to just hit diversion first because there are about 300,000 Native American church members. And the way that the tea is delivered all over the United States. The Santo Daime Church was 100 people. And so all of our drug policy experts testified that there's been no significant diversion of the peyote. And over the last 10 years prior to the case, nobody had really heard of ayahuasca. You folks out here who know about it, it's like 5 to 10 years now that anybody knows about it. But back when we did the case, nobody knew about it. And so there was no evidence whatsoever to suggest that the tea would be diverted because the church was directed by me that every batch of tea will be marked. Everybody will know how much is in there so that if anybody wants to check, it's clear there'll be no diversion. And this is enormously important when you are in this milieu of the government wanting to shut you down, is you've got to do everything absolutely to book. And so the government psychiatrists and toxicologists who were talking about, we'd be walking down the street and people would be lying all over the street screaming in agony from having taken ayahuasca because it's going to be diverted from use in the church. I haven't seen that happen. The biggest issue in all of these cases is who has the burden to prove something. And under this act, the first step is the church has to come in and prove it's a church, and I'm using the term church very carefully right now. And then they have to prove that the government activity is burdening the practice. Now, in the case of the Santo Daime, let me just backtrack a tiny bit. because I'm going to talk about the DEA and what an intellectually and morally bankrupt organization it is. And you know, I'm not just saying this because it's true. I'm saying it because I have evidence of it, okay? Because I've been fighting them for 12 years, happily, successfully. Now, in First Amendment cases, the court generally doesn't challenge the bona fides of a religion. I mean, there's some kooky religions out there. And the government, Santo Daime is a kooky religion. The UDV is a kooky religion. Every religion is a kooky religion. Every practice is a kooky religion if it's not the typical Western. And they are wedded to that. They're not wedded to it intellectually because you really can't be. They're wedded to it because they grew up in a screwed up culture with very myopic views of what people should and shouldn't do. They refuse to acknowledge that the Santo Daime Church was a valid religion. And generally, that never happens, even with those kooky religions. But here, Brazil recognized it as a religion. The Catholic bishops recognized it as a religion. And under the most restrictive conceivable jurisprudence, the Santo Daime was so clearly a religion. At the end of the trial, Judge Panner, when the government lawyer was arguing in closing, Judge Panner, who was our federal judge, I had been before him on a number of other cases, he's an excellent judge, he says to the Justice Department lawyer, "Are you standing up here in front of this court and saying that you do not concede that this is a valid religion?" "No, Your Honor." He said, "I want to ask you again. You're telling this court that these people who are sitting here, who represent a very fine cross-section of America, federal judge talking to the Justice Department lawyer, and you still won't concede it." They wouldn't concede it. And there's so much more intellectual dishonesty that I'm probably not going to get to because my God, I can't even believe what I'm down to here. The other thing that was so dishonest, and Judge Panner took that one apart, we can't trust this church. They've been violating the criminal laws for the last 10 years, sneaking the church into the United States, taking it clandestinely, so they can't be trusted. Of course they're going to give it out to everyone. Judge Panner quite appropriately noted, well, what else were they supposed to do? They were courageous enough to chance being arrested to practice their religion. I'm going to go through it all and just take you right to where we're at. I filed, after Bush came in, I filed the case in federal court against the United States Justice Department. I did not name the DEA. Bia spoke for a moment about how the DEA wants to suck everybody into their administrative process. And when they do that, they will rule against you. And the appeal you have to the federal courts then is not as strong because they give credit to what the government decided. And so when I filed my case specifically, I only named the U.S. Justice Department. But they came in with 4 lawyers, and they said to Judge Panner, you have to dismiss the case right away and let them go through the administrative process. The papers I had presented to Judge Panner included all these letters where they wouldn't tell us what their compelling interest is. And he knew, he's a clever guy, he knew that if we got sucked into that process, we wouldn't be able to make the same kind of a record we could make in front of this judge. And so he said, no, this has been going on 10 years. You're not getting the case. I'm getting the case. I'm going to decide these issues. And so we put together a case with the experts that I've mentioned. I want to just briefly read to you from John Halpern's report. I had really hoped to talk about dose and risk for the scientists in here, and I will just for a second. I want to say to any scientists in here, when you're writing your papers, keep in mind that those papers are going to make their way into a legal proceeding on one side or the other. And some of the scientists that I've listened to, oh my God, some other things, they're experts are saying that all of the Santo Daime people, excuse the expression, I'll say are screwed up. And they're taking the tea for magical solutions to their problems, which is very interesting. And I think everybody gets that. I want to read what Halpern wrote. With reference to the neurocognitive risks from daime use, it might be helpful to consider similar evaluations of peyote. Preliminary data indicate that Native American church members are just as neurocognitively healthy as non-peyote using controls. There are no published reports for either peyote or daime indicating that their religious use causes hallucinogenic, persistent, perceptual disorders. Evidence to date supports continued intact cognitive functioning. It amazes me to this day that the government spent probably $10 million fighting our case. It's the first time ever a federal judge has issued a permanent injunction against the United States, prohibiting the United States from banning the religious use of a tea from another country. So maybe we should just go to questions. Thank you.
What was the name of the Supreme Court case you were involved with?
Smith versus Employment Security Division in Oregon. And by the way, the Oregon Supreme Court ruled in our favor. And then the Supremes in D.C. reversed it.
That's the case I thought you were talking about.
Yeah.
I know that most of the cases, I think, under RFRA deal with a lot of zoning issues. Have there been any other cases after Smith that dealt with the application of RFRA? I mean, I guess the UDV
Well,
case.
there's this much. To my knowledge, there are no other cases that have been filed dealing with entheogens. But I'll tell you this, there is a prosecution that was started in maybe Utah for non-Native Americans using peyote, and that is a huge, huge, huge issue in the United States with the Native American church not being in favor necessarily of white folks going ahead and doing peyote. And again, it has to be parsed, and I'm like a surgeon. These things have to be parsed very carefully. You don't go into court trying to make law that there's no real basis for. And I'm not a nice guy about that, because we don't want to see bad law replacing good law.
I want to make two questions, and I take the liberty to make an announcement that has to do with Roy and I, that I forgot to invite the audience for our ayahuasca workshop that will take place during the 25th anniversary of MAPS in Oakland on December 12th. So Roy's going to be there, and also I and other colleagues. If you want to register, that would be nice. And my question to Roy is if you could comment on this issue of pregnant women and children, if you have any, sorry to bring this controversy, but if you have any comment on that, and if you could also about the DEA UDV comment something.
I'm not going to talk about that, Bia. No, I'm kidding. I'm kidding. As you noted, in Brazil, the government permits pregnant women to take the tea. One of the things that Judge Panner noted in his opinion was, I was in Oregon with the Oregon Pharmacy Board, and our federal judges all around the country, if they can go with what the state is doing, they will. It was a huge thing to have to go into federal court. And Judge Panner credited the Oregon Pharmacy Board and credited the fact that in Brazil, pregnant women are permitted to take the tea. And there is no policy that prohibits it that we have. And if you're asking me about my own personal view on it, I think some of it involves issues about maybe how much tea is taken at, but all the ayahuasca people, all the padrinos, all the madrinas, they've been doing this for hundreds of years, and I would put myself completely in the hands of the Brazilian madrinas about that. And to the extent that their knowledge is here now in the churches, that's where I go with it. That's my answer to it. Was that okay? Oh, yeah.
Could you repeat the comment, because we didn't hear it from the back?
Oh, Bia asked me about the agreement that the União de Vegetal has reached with the government, and I will talk to that. But I have to tell you that in our case, and in the UDV case, what the government most of all is dealing with is their institutional fucked up ego. All right? They want control for control's sake. What happened in the UDV case is they had a preliminary injunction, and they were negotiating over the permanent injunction, and they agreed to a permanent injunction, and the contents of the injunction aren't that bad. What's bad about it is if there's a disagreement, there is no agreement whether it will be resolved within the administrative process of the DEA, which is not where you want to be, or whether it would go to a federal judge. They wanted to do the same thing with us, and there's no way I would voluntarily submit the Santo Daime to having the DEA in the first instance make decisions on any issues affecting my church. And so in our case, if something happens, I've got a federal judge, not a DEA administrator, making the decisions. And that is crucial.
Don't you see an inherent problem with legislation like RFRA and ARLUPA, and what would have actually, in my opinion, happened if you had gotten the contrary result in Employment Division v. Smith, is that it expands the government's ability to kind of define religion while at the same time doing nothing for, as you put it, those of us who are white people who want to use these chemicals. And that the real problem is really in the insanity of the Controlled Substances Act itself, but not in the legal reasoning of Employment Division.
I want to see if I got you right. The first part I heard was, if we had won the Al Smith case, would there have been a necessity for the Religious Freedom Restoration Act? My answer to that is no. We would not have needed that act if the Supreme Court had kept the proper compelling interest test. The second part of what you're asking, I think, has something to do with, and I wasn't clear about, how does that definition of religion hurt the white folks who want to sincerely practice?
If you had gotten a contrary result in Employment Division v. Smith, and what it would have done, I think, much like I think RFRA and ARLUPA does, is it expands the government's ability to define religion, which I think is, inherently dangerous, while doing nothing for the general population who have no ability to be recognized as organized religions, who want to use these chemicals. And the real problem is in the insanity of the Controlled Substances Act.
All right, let me answer it now. I think I can answer your question. First of all, what RFRA did is it simply overrode the Supreme Court decision and reestablished the test that was always there. There's nothing in RFRA or RILUPA that gives the DEA or any other government agency any greater handle to have a myopic view of what religion is. Now, had I had the time, I was going to discuss with you a case involving Pete Seeger when he went conscientious objector status. And in that decision is beautiful, and it's what I'm looking at, because I'm being asked now to go a little bit further than just the Santo Daime. And so the object, the paradigm now that I'm in favor of is looking at new definitions of religion. Not religion, spirituality. We're all one on the planet. We all recognize our limitations as human beings. All of these are paradigms, and I actually meant to bring and make copies of this decision because it talks about the 250 different religions. The Buddhists believe this. There are religions that have 25 different gods, and all of those are valid. And using that case, I'm going to be making additional inroads very carefully. But the answer to your question is no, it did not give the government any additional ability to further narrow the concept of religion.
So speaking of what you're going to be doing in the future, what about Daime in other states? In New York or wherever? For example, is Daime use is legal in one place? Does that make it legal in others? Does the decision in Oregon affect users in other places?
All right. Tough issue. As a matter of the technical side of this all, the case I brought was on behalf of the Oregon churches, okay? And the judgment, the order enjoining the Attorney General is directed toward the Oregon churches. I had reason early on not to be bringing other churches into this. And the reasons were very valid reasons. I'm not going to bore you with them. Right now, it's my position as a lawyer that in light of the existing jurisprudence, that a valid Santo Daime Church that takes the tea is not committing a crime. But I don't have an order protecting New York as such. And at this point in time, a decision has not been made about the next steps in the process. So technically, I imagine the DEA would say, well, people in New York don't have a right to use the tea. But it's the same fallacy they took toward us in Oregon. We don't have the right to use the tea. No, they have to establish that what's going on in New York, that it has a compelling interest. But it lost all the compelling interest arguments already. But we still have to work surgically because the DEA, they don't want any expansion. And one reason they don't is there's a little crack in the wall. And people who grew up in that agency, who've run that agency, whose lives are dependent on the income, they are afraid the wall's going to come down completely, particularly since Obama was elected. And you've seen how they've disregarded some of Obama's suggestions about staying away from the pot issues in California. So, can't give you an answer other than the one I gave you that, in my view, nobody's committing anything if they're following the Santo Daime rules and regulations, and that's about it on that.
Yay. Thank you, Roy. Roy, thank you very much.